Hello friends, Namaskaram. Today I am going to discuss the important topic, the important judgment by Honorable Karnataka High Court wherein a woman was found to be guilty to implicate falsely multiple persons, and apart from that the present FIR and the other proceeding instituted by the said woman amounts to abuse of process observed by the Honorable Karnataka High Court. So we have to consider the entire content in the detail so that we could draw the effective conclusion while we are contesting a false case by a woman. In this case, a FIR has been registered under section 498A, section 504, 506, 149 of the IPC. And apparently it is appearing that it is a casual case against the husband or relative of the husband, wherein the allegation of the concerned wife is that they harassed the concerned woman for demand of dowry, insulted, criminally intimidated, and in the entire scenario, they all were having a common object. But when the matter had brought up before the Honorable High Court, the High Court was totally perplexed from the conduct of the concerned lady while prosecuting the concerned husband and the relative of the husband. The basic facts are that the concerned accused was working with Virgin College Private Limited, and the said institution deals with coffee. And to make the coffee more effective so that the client could be served in the best way, they used to have the raw material from various institutions. On one of the fine day, the concerned lady, through its enterprises named as Deepika Enterprises, inter alia, visited the premises of the concerned accused. She provided various offers, and ultimately the deal was not final, but she never lost the hope. She was in communication, and finally on one of the day, it means after 3 years, that is 23rd of August 2022, a visit Hotel Lalit Mahal Palace. Finally, the relationship inter alia initiated, and consensual relationship had been developed between that lady and the concerned accused number 1, and she lost the FIR on 8th of September that the concerned person had raped the concerned woman. In the meanwhile, another complaint was lodged by her in which she alleged that the concerned relative of the husband inter alia compelled her for marriage with accused number 1, and marriage was performed under compulsion, and in that scenario serious crime has been committed by all of them. The said crime is said to be occurred on 15th of September 2022. When the matter was argued before the concerned court, the concerned defense counsel flagged the same as a crime against man. Because the concerned accused is the 10th victim of the complainant, he submitted that the complaint is not reasonable, it is sheer abuse of process of law. Because when we are going to bring up said cases under questioning, the said arguments or averment are required to be settled in the petition, but mere averment does not amount to prove. We have to submit that the complaint is not reasonable, and we have to provide the reasons for the same. In the present case at hand, the concerned defense is of view that the relationship is not of single day, there is no rape, and apart from that she is habitual to lodge the complaint. Because she inter alia communicated with the concerned accused, she offered herself for sex, and inter alia, when relationship had been developed, she tagged the same as a rape. But in fact it is not a rape, it is a consensual sex between a man and a woman. And apart from that, there was no force to marry her. She willfully do the marriage, performed the marriage, and the concerned defense submitted the proof regarding the same before the concerned court. It is a submission that she lost the 2 false cases against the concerned accused so that huge money could be extorted, and apart from that multiple cases has been registered against her regarding extortion. In addition to this, she also instituted false case for section 125 of CRPC, section 12 of DV8, but all these proceedings are nothing but abuse of process of law. In addition to this, 9 cases had been registered by her as per knowledge on record. Case number 1 has been registered against a person in the year of 2011, wherein she alleged that the concerned person as husband with family harassed her, and in that manner the concerned person was charge sheeted as per section 498A, section 34 of IPC with section 3/4 of DP8. Crime number 2 has been registered by her under the ground that the concerned man had raped her, cheated her, apart from that insulted her and criminally intimidated her. And finally, FIR has been registered as per section 376, 420, 504, 506 of the IPC. The context is that in the false pretext of marriage, the concerned person raped her. As far as crime number 3 is concerned, in which the complaint has been registered as per section 504 and 506 of IPC, means of insult and criminal intimidation. And as far as crime number 4 is concerned, it is registered under section 376 of IPC with section 420 of IPC. Same with crime number 5, same with crime number 6. And as far as crime number 7 is concerned, it is registered as per section 354 of IPC against a new person. And crime number 8 is registered as per section 376 of IPC, and crime number 9 is registered as per the protocol of section 354A of IPC. 9 different person, 9 different FIR by a same woman by alleging that she had been raped or she had been arrested or she had been molested. And finally, 10th FIR has been registered against the present accused. So looking to the facts and circumstances, the court observed that the proceedings are abuse of process of law. Apart from that, even though the report is considered, there is nothing on the record to suggest that the allegations are specific, allegations are vague, does not constitute even an offence, and court, by looking to the facts and circumstances, had quashed the FIR. And apart from that, direction has been given to the concerned police not to register the FIR on the basis of report of such complainant. So the said judgment entirely provided us the way while we are moving for the questioning proceeding as far as the matrimonial and other offences are concerned. When we are going to move for the questioning, our homework is required to be on complete ground. We are not supposed to move on vague grounds. Number 1, we are required to specify what allegations are against us and what specific role has been given to us. Number 2, in which manner allegations are false and what is the correct answer. Number 3, we are required to clarify our stand. Number 4, in case she lost the false FIR against multiple persons and these persons are in our touch, then we could proceed further. And apart from that, with the help of Google, it is very much easier to find about the credential about a person. And in addition to this, we may rely on RTI section 91 of CRPC, which is now section 94 of B and SS. So while availing all these remedies, we could proceed. And apart from that, we are required to suppose the memorandum to the concerned police so that the police could investigate. In case of failure or in case of any charge sheet, then you may proceed or plan to move further. So this judgment entirely provided us the 10 basic guidelines to proceed in case of questioning. So in a nutshell, please note that number 1, in case of any report by any woman against you, do not be panic. First, consider the report. Number 2, consider the allegations and filter them in 2 categories. Number 1, the allegations which are true and allegations which are false. Number 3, the allegations which are false are required to be answered by you, but not on the touchstone of incrimination or confession. Number 4, the police cannot compel you for doing confession. Number 5, in case of any FIR. And as far as the false cases are concerned, means a rape case and any 498A case, if you are having a view that you are not the criminal or you have not done any crime and you are having specific proof, submit them. Number 6, if police is not going to consider the same, you may move for questioning as well in addition to anticipatory bail. Number 7, while making the submissions, make them through WhatsApp, through email, and you may send your advocate also. Number 8, you should take the proper stand in case of failure or in case of zigzag or in case of changing of stand. You might be in trouble. Number 9, your drafting should be proper as far as the concerned cases are concerned. And number 10, your role which is assigned to you is required to be discarded by you by submitting the reasonable answers. If these things are done by you, then definitely you could get the remedy in questioning and anticipatory bail. So there is no need to worry, and these cases are settled and glaring example for you to support your argument as well. Okay now? So in this case, the concerned person got the remedy. But to prevent you to be the victim of such cases where a false report has been lost, be alert while be in relationship with a woman, because if you are in a relationship, you are without any agreement or any papers, you might be in trouble. So relationship might be as a wife, as a girlfriend. So if you are in a relationship with a girlfriend, do proper agreement, that is called live-in relationship. Specify your identity, specify your marital status, specify that it is for sex, not for marriage. Never take any money from that woman. If you want to give, you may give the same through accounts. Okay na? And if she is a wife, then make the proper evident. For example, if she is compelling you to get separate from the family, at that time or from that time, both are equal, you must be alert. Try to have proper recordings, proper conversations between you and your wife. And if in near future she files a false case, then these evidence might be fruitful for you. So there is no need to worry. Be alert and be careful while dealing with your wife and your girlfriend. Okay now? So see you in the next video. Till then, Jai Hind, Jai Bharat.